A client asked me this question recently and it was very important. I thought I'll share it with the public over here as well. Why does every high court insist on the physical presence of the complainant before them when they are entertaining a quashing petition on the basis of a mutual compromise? You see, most other situations, the presence of the parties is not required, right? Unless maybe it is the evidence stage. However, almost every high court, I cannot guarantee for every single high court because I have not appeared before every single high court in the country, but all of the ones where I have appeared, every single occasion when it's a mutual compromise divorce, the high court judge wants to see the face of the complainant / victim / informant before, if they choose to pass a mutual compromise quashing order. The reason why is because high court judges are well aware of the kind of frauds that take place across this country all the time. There are people who do jugaad, who do settlements, who do all sorts of hoodwinking with the victim. Sometimes the accused person, sometimes the accused is involved, sometimes the accused is himself a victim. And in all of these scenarios, the judges understand that there is a huge propensity for the accused / victim / informant to be made a fool of. Maybe signatures are forged, maybe maybe they are fooled into thinking they are signing something which it is not, and they're actually signing on the affidavit and the wakalatnamas, the power of attorney for the quashing petition. And so, just to be on the safe side, because once the matter is quashed, for it to be reinitiated when a complainant wisens up and comes to the court and says, "My lord, this was not me," or "this was not with my consent." And a lot of times another aspect is that the judges don't want a second round of litigation to start just because sometimes a complainant / informant gets greedy again and they think, let me try my luck and go to the court again and say, it wasn't me. And that is why high courts across the board will insist on the physical presence of the complainant / victim. Sometimes you may ask, how do you even know for sure that this is the person who is the informant or the complainant mentioned? A lot of times judges will ask them to produce their identification as well. And very often, especially in criminal cases, the court may also get the presence marked of the investigating officer, and the investigating officer gives their undertaking that yes, I have identified the complainant, who is the person inside the court today who has given their no objection to the matter being quashed. A little long, but a very important understanding of why complainants and informants are mandated to be required inside the court room when the matter is being quashed. On a bunch of occasions though, in the past couple of years, at least before the Delhi High Court, we've been able to successfully have the complainant / informant / victim appear virtually before the court. And again, being identified by the investigating officer, their assent is taken on the record, and then the matter is, goes ahead for quashing. My name is Amish.aggarwala. I'm an advocate on record at the Supreme Court of India. Thank you for listening.